Hey everyone, Chip Kosei here with the next edition of Laws for Life. Everything you need to know in your life based on what I've learned in 25 years of practicing law. If you look behind me, we are at beautiful City Park. We are beside the peristyle looking over the lagoon. Such a pretty day, we couldn't help but to get out and do some of these things outdoors. Wanted to talk to you today about community property. Back in the day where I did divorce work and family law work, you know, there was always a struggle about the differences between community property and separate property, and it pretty much means what it sounds like. But community property is, after the day you get married, basically everything that you have is equally split between you and your spouse. So the way the law looks at it is that you're the undivided one-half owner of everything. And the definition of community property is anything that is derived from either spouse's effort, skill, labor, or industry. Now, there's a few things that are not part of that, such as some of the work that I do in the personal injury arena. If you have a personal injury lawsuit and you get a settlement or you get a judgment, then that is your separate property, even though you may be married at the time that case comes about. So it's very important when you're estate planning, or whether you want to live under some other regime other than a community property regime, to make sure you make a declaration beforehand that you're going to live under a community property regime or a separate property regime, because the decisions that you make and the consequences that flow from those decisions may affect you negatively or positively depending on how you plan. If you have any questions, give me a call, 504-588-9500. You can also email me, chip@koseitlaw.com, and we'll talk again soon. I sure hope you enjoyed this video, and we'll make some more soon. Thanks a lot.